Okay. Um, we have a special treat tonight. We got a gentleman here who's come up all the way from Roanoke, Virginia. Roanoke, uh, Civil War Roundtable. Okay, and he's gonna talk to us about something that I don't think we touched on any martial proceeding. All right, Fitz John Porter, another one of my favorites. Um, his boss, my, of all the Civil War generals. I mean, you know how much I love those two guys. I've been looking forward to this for a long time. This is going to be a great night, great presentation, and I just want to welcome Kevin Donovan. Okay, everybody, give me. You can.
So how do I do a slideshow so that,
Let's see. Yeah.
Do you want me to check the?
Yeah.
Make sure.
The recording's already gone.
It's on.
Come up here and do the slideshow for him.
This is your.
yes,
Okay. So you just need to.
folks don't see what's coming up.
Trying to get your cursor right. Where's your cursor? See it. You see your cursor? I don't see it.
How about that?
Oh, yeah, that's it. Okay. Oh, there's.
Oh, there's.
Should have.
Okay.
That's coming up.
Is it possible to show the audience to see only that, but for me to see what's coming?
Yeah, you can see it here. I think you can see.
But I mean the next slide.
Um, is that the whole thing?
Might want to put it back to where it was, where they're all on the left-hand side, and he can just click on them as he needs them.
I'm not sure how to.
The way it was.
You can escape and go,
Okay.
where it was.
Okay, so that's where.
All right.
Okay.
There you go.
All right, if you don't mind, I'll do it that way.
Just click to the ones that you need, Kevin.
Front light, so.
Yeah, that'd be good.
Okay. Well, thank you very much for coming out. As Kim said, I'll provide a little bit of context. Kevin Donovan, I am a retired, or as I like to say, recovering lawyer. Now living in Roanoke, Virginia. I always have to make that distinction. Most people, when they hear Roanoke, they think of the lost colony. That's North Carolina. We are in deepest, ruralist Southwest Virginia. And I'm here as a recovering lawyer to talk about an infamous court-martial and about Fitz John Porter. Most people, I venture to say, are not very familiar with Fitz John Porter, even Civil War buffs. You may have heard the name, but it's likely that most people are not aware of how important a role Fitz John Porter played in the early months of the Civil War. He was far more important than most people realize. And in fact, how do I do this?
Click on the picture that you want there on the left.
Okay.
Also do the down arrow if you need
Or the
to,
down arrow, either one.
on your keypad.
Ah,
Yeah, he wants to.
he has been referred to as the Forrest Gump of 1861. Because if you remember the movie Forrest Gump, Forrest seemed to show up everywhere, including at some historically significant events. And so too with our friend Fitzjohn. If you look at that, some of those bullet points, you will see that Fitzjohn Porter played a very important role in some very important events of the Civil War as it was developing. He did get around. But jumping forward, what we should know is that by the summer of 1862, Porter had emerged as one of the Union's leading combat commanders. He was the commander of the 5th Corps of the Army of the Potomac under George McClellan during McClellan's Peninsula Campaign. And in that role as 5th Corps commander, he actually beat Bobby Lee's troops at the beginning of 7 days at the Battle of Mechanicsville, otherwise known as Beaver Dam Creek. The next day, he, through skillful defense, held off Lee's forces for most of the day against overwhelming odds. It ultimately took the largest charge ever made by the Army of Northern Virginia to break his line. I say largest charge. Some historians say Lee threw about 35,000 into the charge. Makes Pickett's charge look like a skirmish line. I've seen another historian say it might have been as many as 50,000. But the apex of Porter's career, however, as a military leader, came on July 1, 1862, at Malvern Hill. At Malvern Hill, some historians claim that Porter effectively led the Army of the Potomac. Some disagree, but nevertheless, he was there and played an important role in inflicting a stinging defeat on Lee's forces. Meanwhile, his commander, McClellan, set out the battle on a gunboat in the James River, and for which he was roundly criticized and made fun of. That's a lithograph from the 1864 presidential election referring to McClellan as the gunboat candidate. And that goes back to where McClellan was during the Battle of Malvern Hill, while Porter is, at least according to some historians, actually leading the troops. Porter's performance and his gallant personal conduct won him unstinted praise, especially from McClellan. In one dispatch to Washington urging his promotion, McClellan ended with words to the effect, "Would that the Army had more officers like Fitz John Porter." At that point, McClellan's star is on the rise. Who knows where he might have ended up in the pantheon of U.S. Army generals and leaders of the Civil War if his career had continued on that trajectory. Well, spoiler alert, it didn't. 5 months to the day after Porter's victory at Malvern Hill, Porter found himself in the dock of a court-martial. His career and indeed his life at risk. Porter was accused of disobedience of orders and other misconduct during the campaign of Second Manassas. That's Second Bull Run to us Yankees. He was convicted and he was sentenced to be cashiered from the Army. Plus, he was to be precluded from holding any office of trust or profit under the United States. Porter's last hope for a reprieve was crushed by Abraham Lincoln, who signed an order endorsing the findings of the court-martial. Porter went, with that stroke of a pen, from one of the United States' leading combat commanders of the war to a man who couldn't get a job at the local post office. For the next 16 years, Porter fought for a new hearing, trying to cleanse his reputation. Finally, in 1879, a 3-officer board known as the Schofield Board or the Schofield Commission, named for its chairman, having taken a fresh look at Porter's case, issued a report exonerating. It took another 7 years, but finally in 1886, through an act of Congress, Porter was reinstated to the U.S. Army retroactively with the rank of colonel, and thereafter he promptly retired. But for that 23-year period, and really for the rest of his life, Porter had to endure attacks on his reputation. he was frequently referred to as a traitor to his country for what he had done or not done at Second Manassas. For example, John Pope, who had been Porter's commanding officer at Second Manassas, in the 1880s penned an article for Century Magazine's famous Battles and Leaders series. And in the article, Pope went after Porter again. He flung the name Benedict Arnold around, implying again that Porter was a traitor. And Pope buttressed his arguments by reminding his readers that Porter had been convicted by a court-martial. Well, wait a minute, Porter's allies said. The Schofield Commission exonerated him, cleared him. The problem, from Porter's point of view, is that the Schofield Board not only had the benefit of hindsight, it had the benefit of testimony and evidence from the Confederate side of the battle. James Longstreet testified before the Schofield Commission, and he testified as to when his troops had arrived on the battlefield, how many men he had, where his Confederates were positioned in relation to Porter. Testimony that went a long way to showing that Porter's failure to attack per his orders at Second Manassas had in fact been the right decision. But that does not mean that the decision reached by the members of the court-martial was wrong. Obviously, the court-martial members couldn't wait around for the Confederates to testify in the middle of the war. No, they proceeded to judge Porter based on the evidence before them at the time being 1862-63, when the court-martial was held. Or did they? Porter always argued that he had been the victim of a political vendetta. Porter was a friend and a protege of George McClellan. You saw McClellan thought very highly of him. You probably also will recall that in the summer of 1862, McClellan was in very bad odor with the radical Republican faction. That's the faction that wanted to convert the war from a war simply to restore the Union into a crusade to emancipate the enslaved. The radicals also were pressuring the Lincoln administration to endorse a so-called hard war policy. Don't just fight the rebel armies, bring down the hard hand of war on disloyal civilians. Both McClellan and Porter were well-known opponents of both policies of the radicals. Pope, by contrast, was seen as sympathetic to the radicals. So let's introduce ourselves to Mr. Pope. So, wrong Pope.
That's great.
John Pope. Now, and as an example of how Pope was perceived, that's a contemporary cartoon. You can read the captions, but basically it's showing that Pope is saying that he's tired of fighting the war with rosewater and elder stalks, indicating that he is supporting the radical Republicans' institution of a hard war policy. Now, I had said that Porter led the Fifth Corps under McClellan. So the question is, how did he run afoul of Pope? It happened this way. June of 1862, Pope, who has had some success in the Western Theater, has been called to the East by the Lincoln administration and placed in command of a newly created army called the Army of Virginia. Pope's mission is to drive south and to capture or at least threaten Gordonsville, Virginia, a vital rail link between Lee around Richmond and the Shenandoah Valley. The idea was that Lee would be forced to transfer troops from the Richmond front to defend Central Virginia against Pope, thereby making McClellan's job of taking the rebel capital during his Peninsula campaign that much easier. But before Pope could get moving on his campaign, Lee launched his famous 7 Days Offensive, and he knocked the Army of the Potomac back from the gates of Richmond. As a result, through the month of July and into August, there's a stalemate in the East. The strategic situation has changed, and Pope doesn't have enough men, he feels, to operate on his own, so he's staying in central northern Virginia. Lee is casting a wary eye on Pope's army, which is a threat, but Lee doesn't dare leave Richmond, while McClellan's force, while defeated, is still in the area. McClellan, for his part, refuses to resume his offensive unless he's heavily reinforced, which isn't going to happen. Stalemate. Lincoln administration breaks the stalemate. In early August, they issue orders to McClellan: abandon your campaign, move the Army of the Potomac north around Washington, and start sending reinforcements to Pope. McClellan does not like this order. Among other reasons, he sees Pope as a threat to his command. But the order is reiterated, and McClellan begins the process of transferring the Army of the Potomac from the peninsula back near Washington. And as fate would have it, the first unit that was sent to reinforce Pope was Porter's 5th Corps. Now, Lee quickly figures out what's going on, and he moves his army north to confront Pope. Lee's goal is obvious: destroy Pope's Army of Virginia before it can be completely reinforced and united with the Army of the Potomac. To get at Pope, who is hunkering down behind the Rappahannock River, Lee devises a bold plan. He sends Stonewall Jackson's wing of his army, about 25,000 men, on a very long 56-mile flank march to get into Pope's rear. Jackson succeeds in spectacular fashion, and on August 26, 27, Jackson falls on Pope's umbilical cord to Washington, the Orange and Alexander Railroad, and cuts it. Then, for good measure, Jackson moves to Manassas Junction, where Pope has his supply depot, and burns it. But Pope has a problem. He's lost communications with Washington, he's lost his supply depot, and he's got Jackson rampaging in his rear. However, Pope saw an opportunity in his crisis. As I said, Jackson is separated from the rest of Lee's army, the wing under Longstreet. Pope figures, if I move quickly enough, I should be able to attack and overwhelm the great Stonewall Jackson before Longstreet can arrive on the field to reinforce him. And for the last several days in August, that's what Pope tries to do. He attacks Jackson on August 29. He attacks Jackson on August 30. But on the afternoon of August 30, Longstreet, who by then has arrived on the field, when Longstreet arrived on the field first would be a matter of controversy at the court-martial. But by the afternoon of August 30, Longstreet's certainly there because he launches a devastating flank attack and sweeps Pope's army from the field in a rout. As a consequence, Pope is relieved of his command and his troops are turned over to McClellan. Pope is humiliated. Pope's angry. And Pope goes looking for scapegoats to explain his humiliating defeat. And scapegoat number one becomes Fitz John Porter, hence the court-martial. And what I'm going to do as a recovering lawyer is to go through some of the issues that I've identified, some anomalies in the court-martial proceeding. And we will see, was it fair or was it basically a star chamber type of proceeding? Now, before we dive into what the court did or didn't do to Porter, let's take a real quick look at the members of the court. There were 9 officers, generals, on the court martial. Each one of them had something in common. Each was handpicked for the role by Lincoln's Secretary of War, Edwin Stanton. And that should raise a red flag for any of you who know that at this point, Stanton has thrown in his political lot with the radicals. And he also hates McClellan and the so-called McClellan clique of the Army. Stanton packs the court with fellow radicals, with his associates or friends, and with those who perhaps might have an incentive to find Porter guilty. So, David Hunter will be the presiding judge. He was so radical that he had issued his own Emancipation Proclamation for his military department and started arming the enslaved months before Lincoln was ready for such a move. Ethan Allen Hitchcock was Stanton's personal military advisor and seen to be in Stanton's pocket. Benjamin Prentice, you may remember his name, hero of the Hornet's Nest in Shiloh, was another known radical. Napoleon Bonaparte Buford. Don't you love these Civil War names? And yes, he was the half-brother of Cavalry General John Buford. Buford was lobbied by Stanton. Stanton had Buford and Hitchcock over to Stanton's house for dinner right as the trial was started, to let his wishes be known, apparently. Future President James Garfield was on the court. He was lobbied by Major General Irvin McDowell. And I'm sure you remember McDowell. McDowell lost First Manassas. And contributing to the idea that Manassas is the last place that Irvin McDowell ever would want to build a retirement home, he also played a role in Second Manassas. He led a corps there, but his performance was harshly criticized by General Pope, and McDowell is facing a court of inquiry. So his career's on the line. So he has every incentive to point the finger of blame for the loss of Second Manassas elsewhere. And he does, and he talks to Garfield about it. Silas Casey was another general on the court. He had a grudge against Porter because Porter had blocked Casey from a command while they were on the peninsula together. James Ricketts and Rufus King, they also had led troops at Manassas. Their performance also had been criticized by Pope, and they were facing possible courts of inquiry. So they too, you could say, had an incentive to point the finger of blame elsewhere. The last member of the court was a general named John Slow. I believe he was the military governor of Alexandria, but he was also a longtime friend of Secretary of War Stanton. Now, Slow was also a last-minute replacement on the court. He replaced an officer named William Morris. Morris had served in the old army with Porter and apparently had no problem with him. But worse, Morris raised an objection to the court martial. He felt that the court was illegally constituted. We'll get to that issue in a moment. But as soon as he raised his objection, voila, he's booted, and Stanton puts his buddy Slow on the court. So, from my description, it would appear to be a hanging court, but let's have some faith. So, who is the prosecutor? Prosecutor is this fellow, Judge Advocate General Joseph Holt. He was another Stanton crony. Stanton and Holt had served in the waning days of the Buchanan administration and the cabinet together, and Stanton had gotten Holt this job. So those are the players. We come to December 1, 1862, the first substantive day of the trial. The charges are read. Porter's accused of violating a whole series of orders. To wit, on August 28th, the evening of August 28th, he was ordered by Pope to make a night march. We'll call this the night march order. Pope was very specific in this order. Porter was ordered to start his march at 1 a.m. in the morning. And Pope's order also said it is necessary on all accounts that you be with me by the morning. There was no dispute that Porter violated that order. He was ordered to march at 1. He decided he would wait until 3. He was ordered to be with Pope by daybreak. He was several hours late. The next order is known as the joint order, so called because it was addressed to McDowell and Porter jointly. Now, I won't read it. Porter and McDowell received the order on the first day of the battle, the morning or late morning of the first day of the battle of August 29. I won't read it, but suffice it to say, it's very confusing. It's contradictory, but the important thing is, in Pope's mind, the joint order was an order for Porter to attack Stonewall Jackson's right flank on August 29th. Pope's battle plan for the 29th was he would attack Jackson's center and left flank, pinning Jackson in place, while Porter rolled up Jackson's right flank, ensuring victory. All afternoon on August 29, Pope, while he's doing his attack, launching his attacks, is waiting, listening for signs of battle from Porter. Porter doesn't attack. So Pope issues another order, known as the 430 order. Now, this order is very clear. This order explicitly tells Porter to attack Jackson's flank. The order says, your line of march brings you in on Jackson's flank, attack his flank, and if possible, his rear. Now, in response to that order, Porter doesn't attack. Now, the problem was Pope is operating under his version of the facts on the ground. But Pope actually had a very mistaken view of what was going on the battlefield. This doesn't work.
Working.
It was? This top diagram shows what Pope thinks the battleground looks like. I'm not sure if you can see it, but I'll describe it. He thinks that Jackson's flank runs perpendicular to the road and that Porter is right on Jackson's flank, very close to it, and on the flank, and there's nothing in the world stopping Porter from marching forward and crushing Jackson's right flank. Now, the bottom diagram shows reality. In fact, Jackson had pulled his right flank back. Porter was nowhere near it. And most significant of all, there's a little matter of between Jackson's refused flank and Porter's, say, 9,000 men, there are about 25,000 men under a man called James Longstreet. And that's the situation as of 12:30 on August 29. But in a problem for Porter, Pope is operating under his version of reality. And at this point, after the 430 order not being obeyed, Pope is angry. So Pope issues another order that evening to Porter, march your whole command. Poor Porter can't catch a break. He violates that order too. to the extent that through sloppy staff work, 2 of his brigades miss a turn in the road and march completely off the battlefield, although one does return. So those are the orders that Porter is accused of violating. He was also accused of misconduct in the face of the enemy. The theory there was that even without an order, Porter, you were obligated to launch an attack. Why? Because you knew that your commanding general was engaged in battle and needed help. Now, a prosecutor, a lawyer, wants to have motive. Why would Porter disobey all these orders? Why wouldn't he go to the support of his superior, General Pope? Well, the prosecutor, Holt, had a theory. Holt had in his possession a series of telegrams that Porter had sent before the battle. And in those telegrams, he makes some very, very disparaging comments about Pope, who he clearly despises. And he says, in effect, Pope's an idiot. He doesn't know what he's doing, and Jackson's running rings at him. Worse, in some of these telegrams, Porter makes it very clear he will do anything he can to get out from under Pope's command and back with his friend, George McClellan. And in fact, in one of the telegrams, he's writing these to Ambrose Burnside, by the way. In one of the telegrams, Porter says, "My birthday is coming up." And then he says, "My star always rises on my birthday. I hope that Max, McClellan's, star also is on the rise." Interesting language. And Holt's theory was the reason Porter violated his orders, the reason he didn't lift a finger to help Pope, was because he wanted Pope to lose the battle. That way, in the ensuing crisis, Lincoln would have no choice but to revert back to McClellan and put McClellan in overall command, which, in fact, is exactly what happened. Now, that's a very serious charge because that's treason. And that's why Porter's life was at risk in this proceeding. All right, December 3, the court meets again, and the charges have now been read, and Porter is asked, "How do you plead?" In response to that question, his very able counsel do what lawyers do. They made a motion. The motion by Porter's counsel was that the court had to dissolve itself because it was illegally constituted. Remember, Marx had that objection. The basis of Porter's counsel's motion was that the Articles of War, which govern court-martials, how they're run, mandated that whenever an army commander preferred charges, the members of any court-martial had to be appointed by order of the President of the United States. This court had been appointed by order of General-in-Chief Henry Howard. Now, that's not good enough. Now, you may think that's just some technicality, maybe some cheap lawyer's trick. I never engaged in cheap lawyer's trick in my opinion. I'm told some lawyers. But no, Porter's counsel had a strategy. A trial lawyer will tell you that if you can show that a witness, especially a key witness, has an interest in the outcome of the proceeding, has a bias, it's easier to undermine his credibility at trial. Porter's counsel wanted to get it on the record that General Pope was bringing these charges. Then they would be able to argue that Pope doesn't really believe that in the charges. He's just looking for a scapegoat. Now, this motion led to the first anomaly of the court-martial. In response to the motion, there was a colloquy between Holt as prosecutor and Porter's defense counsel, which went something like this. Not as clean, but it went something like this. Porter's counsel: "We wish to know if General Pope is bringing these charges." Judge Advocate General Holt: "The order appointing this court doesn't say who's bringing the charges. Porter's counsel, yes, we know that, but isn't General Pope behind the charges? Holt, oh no, the charges are signed by General Benjamin Roberts. Porter's counsel, we know that too, but Roberts is on Pope's staff. Isn't Pope actually using Roberts as his agent to bring the charges? Holt, certainly not. General Pope, in fact, has never brought any charges against General Porter. Porter's counsel, is that so? Here's an order issued by Halleck just a few weeks ago, referring to a court of inquiry. And the purpose of that court of inquiry, according to General Halleck, is to examine charges against Major General Fitz John Porter brought by Major General John Pope. Hold. Pay no attention to that order. That court never did anything. It was dissolved. Well, that's true. The court of inquiry that Halleck was referring to was dissolved so that it could be reconstituted into the court martial with exactly the same members, except Morris was replaced by Slough. So there's this back and forth. It's not quite as crisp, but that's the substance of this silly back and forth. And of course, as you suspect, Pope was behind the charges. And it came out later that Pope had gone to his staff member Roberts and said, I will get you a promotion if you put your name on the charges so that I can keep my skirts to. But the anomaly is that during this nonsense back and forth, nobody on the court speaks up. Nobody on the court asked the obvious question of Holt. Come on, is Pope behind the charges directly or indirectly? Tell us true as an officer of the court. No. Rather, the court retires to consider the issue. Holt joins them in their deliberations. Now, I don't think that was considered unethical at the time. Holt was their legal advisor. But the fact is, every single time, except once, every single time the court retired to consider some issue, some evidentiary issue, Holt would join them, and the court would come back, and whatever the issue was, they'd rule against Porter. And here, the court retires, comes out and says, motion denied. So Pope gets to testify as a simple, objective truth teller, rather than somebody looking for a scapegoat. Holt then promptly calls Pope as his first witness, and the court's treatment of Pope furnishes the next anomalies. Pope's direct examination by Holt was pretty standard. I issued these orders. Porter didn't obey them. Okay. But Pope was permitted to go beyond simple telling of facts and what had happened or what had not happened. And he was allowed to offer his opinion on the consequences. Pope was allowed to testify that if only Porter had obeyed my orders, we would have won a great victory over Stonewall Jackson. He was also allowed to testify that it was because Porter disobeyed my orders that we lost the battle, and that placed the safety of the capital at risk, and by extension, the loss of the war. So Pope is doing a very good job of smearing and scapegoating Porter. And there are reporters in the room, by the way, taking all this down. Then Porter's counsel gets a crack at Pope on cross-examination. Yes, sir.
Quick question. You keep saying Porter's counsel. Who was it?
Reverend D. Johnson was one of his counsel. Reverend D. Johnson, a well-known figure. He represented Dred Scott's purported owner in the Supreme Court case. He was on the verge of becoming a United States Senator from Maryland. He had been a U.S. attorney, crackerjack lawyer, a Democrat also. And the co-counsel was, I believe, John Ames. Don't know much about him other than he was considered a nationally known trial lawyer. So he had good counsel. So Porter's counsel gets their crack at Pope on cross-examination. First, they asked Pope to confirm that shortly after that night march incident, that Porter had met with Pope and Porter had explained why he had done what he did, why he modified the order or compliance with the order, and that Pope had told Porter, I understand what you did made sense, no problem. In response, Pope says he can't recall any such meeting. Now, a lawyer will tell you that when a witness says, I don't recall something, that's not a denial. That is simply, I don't recall whether or not something happened. Some witnesses, never mind, not mine, but some witnesses use the I don't recall crutch when they don't want to come out right and lie and deny something. Although, as I've told witnesses in prep, if you remember something and you say you don't, that is a lie. But I think that some people psychologically feel better when they're lying under oath if they say, I don't recall. Also, if other evidence comes up that might impact the issue, they can then back up and say, oh, now I remember based on what you just showed me or something like that. Keep that principle in mind. That's why I'm harping on it. Here, however, pressed for a straight yes or no, Pope finally conceded, yes, I might have had such a meeting with Pope or Porter. And yes, I might have told Porter I was satisfied with his explanation. But then he quickly added, but in my own mind, I wasn't satisfied. Bringing up the question of why are you lying to Porter, but okay. Porter's counsel then asked a broader question, asking Pope to confirm that shortly after the battle, he had another meeting with Porter. And in that meeting, Pope had told Porter that he was perfectly satisfied with Porter's conduct in the late battle, including the manner in which Porter had carried out his orders. Now, in response to that, Pope says, that never happened. Porter's counsel then says, well, don't you remember that your own chief of staff, George Ruggles, once reminded you of that conversation? Now Pope's got a problem. He now realizes his own chief of staff is talking to the defense. So what's he going to do? Call his own chief of staff a liar? Pope says he doesn't remember that conversation with Ruggles. Then he says, I am very certain Ruggles never said such a thing. But I'm not willing to swear to it. I have no knowledge. Pope is all over the lot. His credibility is starting to crumble, and he's opening up potentially a huge hole in the government's case. Because if the commander of the Army of Virginia had once told Porter, I have found no problem, no fault with how you carried out my orders, why is the government prosecuting Porter? Next, Pope, who probably is a little flustered on the witness stand under this cross, he volunteers, I did tell General Porter that as matters then stood, I would not report his conduct I would not report him to Washington. Now that was a mistake. And Porter's counsel pounced, asking Pope, if, as you have said, you believe that the accused violated your orders, and that caused the loss of the battle, and that placed the very safety of our capital at risk, why is it then that you told him that you would not report him to Washington? Snap goes the top. It's a very good question. And Pope has no answer. Instead, in what must have been an act of desperation, Pope, the witness, announces, the question is irrelevant. I refuse to answer it. Well, from your chuckles, you know that witnesses don't get to decide which questions they'll answer. That's the province of the court. Obviously, somebody on the court should have spoken up and said, General Pope, just answer the question. No. It was certainly a proper question, as also shown by the fact that Holt, the prosecutor, didn't object to it because he knew it was proper. So what's the court actually do? They announced they will retire to consider the issue. What's there to consider? There's no objection. Nevertheless, they retire and they come back after meeting with Holt again, and they announce the question is improper and we are directing General Pope not to answer it. In response, Porter's counsel produces immediately a formal written protest with argument. And again, there are newspaper reporters watching all this. Things are not going well for the government's cases. And it's at that point that the presiding judge, Hunter, decides this would be a good time to break for the day. The break accomplishes two things. It gets Pope off the hot seat where he's not doing well, and it gives him overnight to figure out a way out of his dilemma, which he does. Holt met with him, and they figured out what to do next. So the next day, Pope resumes the witness stand, and surprise, surprise, Pope announces, now I would be happy to answer that question from yesterday. Now that puts the court in something of a bind because they've already ruled the question's improper and actually ordered him not to answer it. They meet with Holt again, and they come back and they say essentially, we'd love to hear your answer, General Pope. At which Pope goes into a long, clearly well-rehearsed speech. And among other things, he says, now I remember there was a meeting, and now I remember what we were talking about. I had learned that Porter had sent some telegrams and written some letters disparaging me, and I got in front of him on that. And when he gave me his explanation, I said I was satisfied with that explanation. That's what we were talking about. And as far as not reporting him to Washington, well, I never said I wouldn't file a report with the government. That's all I've done. I haven't brought charges against him, which of course was not true. Now, as an aside, Porter did actually write a letter disparaging Pope before the trial, and you see how he referred to Pope as an ass. That letter was written before the Second Manassas campaign, before Porter started reporting to Pope. Porter, who would be a nightmare of a client, especially if he ever had access to email, he had a habit of putting things in writing that he shouldn't have. He sent that letter to a mere acquaintance of his in Washington. The acquaintance showed it to a cabinet member. The cabinet member showed it to Lincoln. Lincoln showed it to Pope. Not a way to win friends and influence people. So, but whether you like the answer that Pope gave or not, it got him off the hot seat. So the cross-examination continues, and Porter's counsel start scoring some points, including they get Pope to admit that at the time he issued the 4:30 attack order, attack Jackson's flank, he really didn't know where Jackson's flank was. And he really didn't even know where Porter was at that point. So Porter's counsel tries to go in for the kill again. And they ask this question: would you have excused Porter's failure to comply with that order if Jackson's flank weren't where you thought it was, Porter wasn't where you thought he was, and if Longstreet were on the field in front of him? In other words, the reality. And then you can argue about whether the reality is proven by the facts. But it's a perfectly good question. But before Pope can give the only obvious answer, which would be, yes, of course I would have excused his noncompliance, before he can be forced to answer, somebody on the court finally speaks up. And whoever it was said, that question is improper. It calls for mere opinion. Like, what? No, it doesn't. It's a perfectly proper question. Opinion has nothing to do with it. Again, Holt, who's nobody's fool, Holt hadn't objected to it because it was a proper question. Not to mention, as I mentioned, Pope had been allowed to give his opinion up and down when it hurt Porter. Nevertheless, the court adjourns again and comes back and says, General Pope is not to answer that question. It calls for mere opinion, and so that there is no misunderstanding. We are not allowing opinion testimony in this court. So Pope gets to slither off the witness stand, helped by repeated timely interventions from the court. Holt then calls First Lieutenant Drake McKay, the messenger who carried the night march order, brief testimony. Then he calls Benjamin Roberts, Pope's Inspector General, member of staff, and Porter's nominal accuser. He signed the charges. And very quickly into Holt's direct examination of Roberts, Holt asked Roberts, what in your judgment would have been the result had General Porter attacked Jackson at any time up to 7:30? Objection. Calls for an opinion. And I'm sure Porter's counsel was very confident in his position because the court had just moments before said no opinions. Well, the rules apparently had changed. And the court said, we'll allow it. And Roberts dutifully responds, oh, if only Porter had attacked, I think we would have bagged Jackson. Now, the court's failure to pin down who was bringing the charges, its inconsistent application of the opinion testimony rule, and its repeatedly bailing out Pope when he got in trouble, weren't the only anomalies. Witnesses who were hostile to Porter were allowed to testify about what they thought was going on in Porter's mind, to speculate. Drake McKay, the courier who had carried the night march order, for example, he testified, I handed the order to General Porter, he looked at it, and I think right then and there, he decided, I'm not going to follow this order. He didn't have any real evidence for that. Porter never said he wasn't going to follow the order. He never said he was going to amend it. But McKay was allowed to so testify. This fellow, Lieutenant Colonel Thomas Smith, another member of Pope's staff, he gave a veritable psychological profile on the witness stand of Porter, who he had never met before the battle and whose entire interaction with Porter consisted of maybe a 15-minute conversation. Smith testified, for example, that Porter's whole manner, body language, I guess, was sneering and indifferent when it came to Pope and his orders. On cross, Porter's counsel said, you never met the guy before. Maybe that's just the way he is. And Smith responded, in effect, oh no, I know these things. And he was only sneering and indifferent when it came to Pope and his orders. Smith testified that in his view, Porter looked to him like a man with a crime on his mind. He also was allowed to repeat an inflammatory comment. He said that when he got back to Pope's camp, he told General Pope that I was so certain that Fitz Porter was a traitor that I would shoot him that night, so far as any crime against heaven were concerned, if the law of man would allow it. Smith also testified that when he got back to Pope's camp, the first thing he did was to have his tent pitched so he could be comfortable. And then he went off and got himself something to eat. And only after those essentials had been taken care of did he wander over to General Pope to say, oh, by the way, your left flank is in the hands of a traitor who should be shot. That's the kind of nonsense that was relied upon by the court and by Holt in a post-trial report summarizing the proceedings for Lincoln. Holt relied very heavily on, among other witnesses, he relied very heavily on Smith. That nonsense. Our old friend Irvin McDowell testified, and he gave testimony harmful to Porter, which hurt Porter. And I don't mean just legally. Porter thought that McDowell was his friend. But as I indicated, McDowell was facing a court of inquiry. His career was at risk, and he apparently had no problem in throwing Porter under the bus, or the wagon, as the case might be. And interestingly, when it came time for his cross-examination by Porter's counsel, McDowell suddenly developed what I'll call selective amnesia. Anytime he was asked a question whose truthful answer would help Porter's defense, McDowell had a pattern of, I don't recall, I can't remember, I can't say, I can't be sure. Highly selective. Now, finally, Porter's counsel ended the cross, and perhaps they thought, well, I've shaken his credibility because I've shown that his lack of recollection, his amnesia is highly selective. And counsel may have been right, because the next day, McDowell was recalled to the witness stand, not by Holt, the prosecutor, but by the court. And a member of the court proceeded to lob a series of softball questions, leading questions, at McDowell, clearly designed to plug some holes that had been punched in the prosecution's case. And as an aside, I've said several times, a member of the court, we don't know, because the transcript doesn't say which member of the court is doing this, but I strongly suspect it was Garfield. And in a writing shortly after the trial, Porter wrote that at this point, when McDowell was brought back and was being fed these questions by this unidentified court member, Porter said, at this point, that member of the court was basically taking over the role of prosecutor. Now, despite the handicaps imposed upon them, Porter's counsel was doing a credible job. And that apparently was thorough for somebody. Because in the middle of the trial, General Hunter, the presiding judge, he starts grumbling. It's on the record. You can read it. He starts grumbling. This trial is taking too long. It's being stretched out, and I know why. It's because of the extended cross-examination that's being engaged in by counsel for the accused. Can you imagine that? Defense counsel is actually defending his client. So Hunter announces that the court is desirous of resuming the usual and customary practice with respect to court-martials, specifically that the accused will question his own witnesses personally. Now, Porter's no lawyer. This move to make him be a lawyer would cripple his case, which clearly was the point. Porter protested, pointing out he had been promised that he could use trained professional counsel in his defense. It's a capital case, after all. The court was unmoved. Unmoved, that is, until Porter cleverly pointed out, well, if you really want to follow the usual and customary practice, then I will insist upon my usual and customary right. After each witness testifies on direct, I get time to go back and write out my cross-examination questions and have them read to the witness, and that's going to take a lot longer than if you let my trained counsel get up and start the cross immediately after the direct is over. Poised by the illogic of their own rationale, the court backed down. That's the only time they adjourned, considered, and ruled in Porter's favor. And my speculation is somebody said, guys, this is a bridge of unfairness a bit too far. Now, the prosecution's case ended with the introduction of those damning telegrams. And even here, there was unfairness. Porter's counsel objected that Holt was only introducing some of the telegrams that were sent. He was cherry picking the ones to hurt Porter. Porter's counsel said that there were other telegrams that had important context and also had exculpatory evidence helping Porter's defense, and that they had asked Holt for copies of all the telegrams, and Holt had ignored them. Faced with this clear prosecutorial misconduct, the court basically yawned. Didn't even respond to Porter's counsel's request. And then when Porter's counsel tried to introduce the couple of telegrams they did have copies of, the court excluded them. Oh, they're irrelevant. Except for one, they did let Porter's counsel introduce one telegram, which was kind of odd because Holt had already introduced a copy of that same telegram. Except for the minor difference, Porter's copy proved that Holt had altered the text of his copy to make Porter look bad. Faced with that even clearer prosecutorial misconduct, the court, if it were even possible, double yawned. Didn't even ask Holt to explain. Now, we don't have time to get into Porter's defense. Suffice it to say, it was vigorous. He called many witnesses, including the felon. But I do want to touch upon one key defense witness, Lieutenant Colonel Frederick Locke. Lieutenant Colonel Locke was on Porter's staff, and he testified that he had been sent to deliver a message from Porter to General Rufus King on August 29, first day of the battle. And that after he had delivered his message to King, General Irvin McDowell, who happened to be with King, McDowell gave Locke a message to take back to Porter. McDowell's message was, and it was verbal. His message was, give my compliments to General Porter. Tell him I think he had better stay where he is. But if necessary for him to fall back, he can do so on my left. Locke gave that message to Porter. Now, that's bombshell testimony because McDowell outranks Porter. And this is an order. Stay where you are. In other words, don't attack. Right there, Porter is exonerated from the most serious charge against him, failing to attack during the afternoon. So from the government's perspective, Locke's a problem. Locke's credibility has to be destroyed. Now, Holt cross-examines Locke, and he gets nowhere. You read it. Locke's testimony is clear. It's definite. He provides details. He's confident. It has the ring of truth. Holt calls McDowell back. And in this instance, you know what Holt needs from McDowell. It's very simple. He needs McDowell to say, Colonel Locke is lying. I never said that. Thank you. That's all he needs. But in this instance, McDowell's manner of testifying, his, I don't recall, I'm not sure, maybe, it actually kind of helped Porter because McDowell was asked, did you have such a conversation with Locke? And he testified, I've been thinking about it. I've been thinking about it. I don't think so. That's hardly the hell no that Holt needs. The court starts peppering McDowell with questions. They want him to say that too. And the closest they get to that from McDowell is when an unidentified, again, court member asks this question. General McDowell, are you confident whether or not you had such a conversation with Lieutenant Colonel Locke? And I'm going to pause because McDowell's answer on the transcript, the cold transcript just doesn't do it justice. And I'm going to speculate. If you've read enough of McDowell's testimony, you can perhaps speculate the tone in which he gave the answer to the question. General McDowell, are you confident whether or not you had such a conversation with Lieutenant Colonel Locke? McDowell's answer, I don't think so. That's how I imagine McDowell answered. It's just not hammered. But Holt had another string to his bow. Now, the key conversation obviously is between General McDowell and Colonel Locke. But Locke had mentioned there was a witness to this conversation. Rufus King was there. Now, can anybody tell me at this point of the trial where physically is Rufus King? The hospital, isn't it? He's not in the hospital. He's closer than that. The court. He's on the court. He's a member of the court. He's a judge. Holt calls King off the bench and turns him into a fact witness. And King promptly says, Locke, I never saw that guy in my life. And General McDowell never gave such an order. Now, Porter's got a problem. What's Porter going to do? Porter's counsel going to do? Call a member of the court a liar? They tried what I would call a flank attack, which should have had good results. They asked King to confirm what probably everybody in the courtroom already knew. that in the days leading up to the battle on the 29th, King had been very ill. King suffered from epilepsy. And in the days leading up to the battle on the 29th, it's pretty clear that he had suffered multiple epileptic seizures. On, I think it was the 27th, he spent the whole day in an ambulance being tended by his division surgeon. On the 28th, the Battle of Bronner's Farm, King's division is attacked by a portion of Jackson's forces. It's a hot battle. Things are not going well for the U.S. forces. An officer is trying to find King for orders. Can't find him. Why can't he find him? Because King has gotten off his horse in the middle of the battle and is lying flat on his back, arms stretched out. At first, those surrounding thought he had been shot or struck by a shell, but no. Then they thought, my God, he's drunk. But no, I think he was having an epileptic seizure in the middle of the battle. And Porter's counsel also brought out the fact that on August 29, when he was with McDowell, King was not with his division. And the reason for that is King had finally bowed to the inevitable and realized that he was in no medical condition to lead troops and had relinquished his command in battle. A very serious thing. So you see where Porter's counsel is going. What they want from King is an admission, and there would be no dishonor in King to do this, that you were so stricken with illness and so afflicted that your memory could not possibly be good, and you probably didn't really know what was going on around you. They just need I could be mistaken. But no, King doubles down and he buries. He says he's sure. Now, was King lying? I don't know. I just know he had an incentive to lie, and I certainly know he never should have been on that court. And then after he's now been a fact witness, what happens? He goes right back on the court and continues, participates in the remaining proceedings and participates in the deliberations. So even if a member of the court wanted to talk in deliberations about, well, what about Locke? You don't think that another member of the court might say, hey, King already took care of him. Are you calling King, our buddy King, a liar? Highly unethical. The final unfairness came with closing arguments. It was well established that as a matter of fundamental fairness, the accused always gets the last word. They get to hear the prosecution's summary, and then they get the last word in closing arguments. So naturally, Hunter turned to Porter's counsel and said, you go first. So Holt gets to hear Porter's whole closing argument. And then Holt announces, somewhat curiously, I waive my closing argument. It's a little surprising. But what he did then is he put essentially his closing argument in a post-trial report to Lincoln, which Porter's counsel doesn't get to see, let alone rebut, to get the last word. Now, in that post-trial summary, it's filled, as you might expect, with half-truths, inflammatory statements, one outright lie. However, and I want to make sure I get this quote right. However, you'll be happy to know that Holt assured President Lincoln that the proceedings against General Porter were scrupulously fair and that he had nothing to complain about. Holt said that Porter was given every indicia of due process, stating, quote, the court was not only patient and just, but liberal, and in the end, everything was received in evidence which could possibly tend to place the accused in its true light. It is not believed that there remains upon the record a single ruling of the court to which exception could be seriously taken. It would be comical except for the hammer that's about to come down on Porter's head. Lincoln reads the report. He is predictably inflamed, and he signs the order endorsing the findings and the sentence of the court martial, and thereby made Fitz John Porter the last casualty of second analysis. Thank you.
All right, how about some questions?
I got the time frame of the charges after the battle, because Porter was at Antietam.
Yes,
Did he know he was being court-martialed at that moment?
that's a couple things. One, he was after Second Manassas, he was relieved of his command. I think Lincoln did it himself. And also somebody else that Pope had a problem with, I think French, who failed to get his division or his corps to reinforce. Action was taken against Porter, but McClellan went to Halleck and said, I have to have Porter. I need him to go after Lee and French. And that they were released. Stanton agreed and Halleck agreed. They were released. Now, did Porter know that? I've read a historian, I think it was Kevin Pollock, who said he doesn't think Porter was aware of that. But how could McClellan not tell his friend? But so anyway, Antietam happens, or Sharpsburg, as the case may be. And interestingly, either in late September or early October, Pope is getting angrier and angrier because nothing is happening to Porter. And there's a letter in the historical record. He wrote a letter. I don't know if it was the end of September or I think it was October. Pope writes a letter to Halleck, and he complains, I have been exiled to Minnesota. That's where Pope was sent. And people like Porter and Franklin, nothing has happened to them. And he basically threatens to go to the newspapers. And Halleck writes back and he says, call your jets. You know we had to reinstate them to command because of the emergency in Maryland. Don't worry, a court is being put together.
I haven't read Bill Marvel's book. Thoughts on how he treated Porter?
Bill Marvel, yes, it's an excellent book. I recommend.
Wasn't he like Otto Eisenschimmel or someone like that was the last one to treat it before Marvel really took a run on it?
Otto was an early one. Kurt Anders has looked at it. And there's another author, I don't list him there, who has looked at it, but William Marvel does a wonderful job. I think he's very balanced. And he also comes down on where I come down, that it was unfair. He raises an interesting question. Did Lincoln ever read the court transcript? The court transcript, obviously handwritten. It's about 900 pages. Lincoln had it in his possession at most 2.5 days before he signed the order, cashiering Porter. Lincoln claimed that he read the transcript. If he read it, shame on him, because he was a good lawyer by all accounts. He would have seen what was going on. Maybe he skimmed it. Maybe he read only parts that he was interested in. But he claimed to have read it. I'll just leave it at that.
When you said that he was later on when he was absolved of all this, him back to Colonel of the regular army. That was his last rank. So he was a brevet major general? No, he was a major general of United States Volunteers. Okay. You've got, for those who may not have, during the Civil War,
you have regular Army rank, that's permanent. That's what every career officer wants, regular Army rank. But for the Civil War emergency, the government raised United States Volunteers. And that rank, the United States Volunteer rank, went away when the war was over. And then you could be a major general during the war, but if it was volunteer rank, you like George Armstrong Custer, he was bumped down to, or he was commissioned
Captain at the end.
well, but by the time of Bullhorn, he was little boy going. He was lieutenant colonel.
Yeah. The rank he achieved after the war.
Yes.
When the war ended, he reverted to captain.
Captain, regular Army captain. Any other questions? Anything else?
Is, did you say that General Ricketts was on the?
Ricketts, yes.
Ricketts, talking about anomalies, Ricketts, I remember correctly, was the one that was holding Thoroughfare Gap and notified Pope, I believe, on the night of the 28th that Longstreet was arriving on the field. And they ignored that. And yet that seems to be the whole process. But Pope, Porter had, Longstreet's corps in front of him, and you said on your thing, refused to that, but yet you got a guy on the board that knows that order was, that information was given to. If they never questioned that either.
I describe Pope as for Pope's actions. What's the phrase? It's a World War II phrase fighter pilots use. Target fixation. I think Pope was so fixated on his perceived opportunity. He's got Jackson right in front of him. If I can destroy Jackson, I'll be a hero. And I think he fixated on Jackson and he just wouldn't listen to anything else. But it's even worse. Real quick, when McDowell is with Porter in I think the late morning of the first day of the battle, McDowell receives a dispatch from John Buford. Probably the only good decision Pope made during the campaign was to make John Buford his cavalry chief. And McDowell gets a dispatch from Buford. I might get the time a little bit wrong, but it says, I, Buford, observed at 9:45, passing through Gainesville, which was a few miles to the west, 17 regiments of rebel infantry, 500 cavalry, and a battery. Obviously, that's Longstreet on his way and pretty close. McDowell takes the dispatch, reads it, tells Porter about it, and then yes, McDowell puts it in his pocket, rides off to see Pope, and never shows him the dispatch until later that night. I guess he forgot.
One more question is, Porter's receiving all these orders. I guess they're transmitted by courier, right?
Right.
In all instances. Are there any messages going back from Porter directly to headquarters to Pope, especially when he's getting the order to attack Jackson's flank, which is now apparently covered by Longstreet, and indicating any reservations on his part, or advising Pope that the situation may be changing on the ground from what Pope perceived at the time he sent the order.
He is sending, from what I've read, he is sending dispatches. Some of them may not have gotten to Pope, but he's sending dispatches. Among other things, he's saying, "What do you want? What do you want me to do?" Now, the 4:30 dispatch that explicitly says attack. The question for the court in that case, the 4:30 dispatch was, when did Porter himself get the dispatch? Porter never testified at the court martial, by the way. His witnesses testified that dispatch did not arrive at their headquarters until darkness was falling. The courier who carried the dispatch testified that no, I delivered that dispatch. I think he said 5:30. as opposed to Porter's people like 6:30, 7. But the courier said it was no later than 5:30. And if you can't believe the word of a courier who is John Pope's nephew, I don't know who you can believe.
I thought that, to answer your question, I thought that every time that Porter said, there's a large enemy force in front of me, Pope was sending back south. It's only Stewart's cavalry. You got to stop.
You're right. I'm sorry. You're
Stop
right.
exaggerating, Yeah.
Yes, sir.
From out of curiosity, where was John Porter at Antietam? Exactly, when he arrived on the field, where did he engage in his attack?
At Antietam?
At Antietam afterwards.
That I don't know.
He was in front of the middle bridge. And the only reason it's probably one of the crucial moments of the Civil War, because he had I think it was him and elements of the Sixth Corps, 30,000 men on the other side of the middle bridge, hadn't fired a shot yet. And opposite him was about 600 Confederates. And when people suggested to McClellan, you should attack with the Fifth Corps over the bridge, you'll drive right through the Confederate army. Porter said to him, "Do you realize I command the last reserve of the last army of the Republic?" And I don't think that would be wise to do. It's one of the moments in the Civil War that could have changed history.
The center of the Confederate line? It's the
Yeah,
center.
so ironically, it was Cemetery Hill. It was Cemetery Hill at Antietam too.
Is that Long Street?
And-
Is that
and,
Long Street in the center?
That was his part of it, but by that point, there had been no, they had moved all the troops off. Like, up obviously along the Bloody Lane and stuff, and it was like 1 or 2 regiments left. Had attacked, that would have been, who knows what would have happened.
Right through the center.
That's where probably, that was probably Porter's worst moment.
Okay. Anybody else? All right, wait, before you do that, let my kids, they gotta go to class tomorrow. Any of my students that wanna leave it, get the full credit, and all that. If you don't, you wanna stay and win a book, you're gonna get the book one way or the other if you have a ticket. But, that's your choice.